affirmative claim with the Department of Fair Employment and Housing, and in essence, sometimes they file competing claims in different forums. So the remedy that is available to an state employee who believes he or she has been discriminated still exists, just with a different form. The concern that I've heard raised, and I want to dispel that, is what happens in a situation when an employee is faced with an adverse action and the employee believes that that action is retaliatory or discriminatory in nature. That employee still retains that right to raise it as an affirmative defense before the board, and the board will consider those arguments. So in essence, there is no deprivation, I guess, or lack of avenue for recourse. There should be no real impact on that issue, okay? And I leave it to Phyllis to maybe address how the FEH intends to maybe handle some of those things.
The Department of Fair Employment and Housing is a state civil rights agency, and we enforce 4 laws, including the Fair Employment and Housing Act, which is a comprehensive employment housing discrimination law for the state of California. Actually, anybody who needs to file an employment complaint and wants to go to court must exhaust their administrative remedies with my department by filing a complaint, which is also jointly filed, if applicable, with the U.S. Equal Employment Opportunities Commission. And we received more complaints, actually, many more than the State Personnel Board. In between 2008 and 2010, my department received 54,801 employment complaints, of which 1,346 were brought by state employees. Now, the State Personnel Board, as I understand it, receives approximately 100 complaints, discrimination complaints from employees, which represents about less than 0.5% of the discrimination complaints brought. So actually, my department is the primary agency for resolving these cases, for investigating the cases, for prosecuting these cases before our sister agency, the Fair Employment and Housing Commission, and also for cases that opt out to court, which constitute about half of these complaints that we finally investigate. We also prosecute those cases. So actually, this remedy has always been around. The statutory remedies available is actually broader than what's offered under the State Personnel Board. Basically, there's a duplication of effort, and that all those complaints can be transferred to my department with no additional expense, and we already process them. So it's really no different than what has always been available.
So as I can follow up on that, so does that mean the departmental internal discrimination complaint process would fall to the side as well?
Internal? I don't understand what you mean. Internal to my department?
No. The departments have an obligation under the law to do an internal investigation. So employees file with the department first. It's not a prerequisite to going to DFEH, but DFEH certainly encourages employees to first address the complaint with their department so that they can resolve it at the earliest opportunity.
But with the elimination of the statute, would that still be the case?
Yes. I mean, under the FEHA, employers have an obligation to take immediate and appropriate corrective action. So employees should be going to their employer to give them the opportunity to resolve it. It's not a requirement, but they should. And I don't want to speak for Phyllis, but when I was at DFEH, we certainly encouraged employees to go back to their department if they hadn't already and try to resolve it before they file the formal complaint with DFEH.
But a department can simply advise them of their rights to go to DFEH directly.
Sure. I mean, they should be.
Yeah,
they should be.
Every department, every employer is obligated to have postings that would tell employees how to file a complaint, including going directly to my department or going directly to the EOC. So that has not changed. In addition, my department offers other resources that would be available to state employees, such as conciliation and mediation. We recently established a mediation division that has been extremely successful and settled within the first 6 months of its operation 121 mediations worth about $1 million. And I expect that our mediation division will continue to grow and be able to basically settle as many cases in terms of damage awards or settlement awards as our legal division. So there are a lot of resources available to state employees, and I really think that it's probably easier to come directly to our department because we're set up to do this work. This is our business.
And just to respond to your second question about the Civil Rights
Yeah.
Unit, so that will be transferred entirely over to the Cal HR. So we have our bilingual services program and our civil rights officer, and all of that will be LEAP program. That will all be going over to Cal HR. So
Well,
those functions are not being eliminated.
Well, the organization chart shows those functions moving out of the Civil Rights Unit, and the language says they will be going to other divisions in Cal HR. My question is, which divisions and who's going to do the work?
Well, if you look at the organizational chart, under statewide services, this proposed chart, it does have the Office of Civil Rights, and that's where...
Right, but if you take a look at the SVB org chart, it has the functions underneath, and the language in the reorganization plan says that those different functions are going to go over to different divisions in Cal HR. So my question is, which divisions? The bilingual services, which division?
Right, it'll be
LEAP, which division?
the new statewide services division,
Okay, thank you.
right?
Thank you.
Hi, my name's Barbara Allen Brescher. I'm an administrative law judge with the State Personnel Board, and I have a couple of questions relating to the discipline statutes, since that is where my focus is, specifically Section 80 of the bill, and then the proposed Section 19573, and then the Section 82, proposed Section 19582. And thanks, Gerald, he's already addressed a couple of the issues, but I have a couple of follow-ups. I too am concerned about the ability or the impact on the State Personnel Board's constitutional authority when the new department, HR department, is going to be implementing this disciplinary criteria that you're referring to. And I see a lot of problems with that. Having presided over countless numbers of corrections actions with their matrix, and looking at it from the perspective of they have a very sort of limited kind of classification, peace officers basically, and there are significant issues with how that is implemented. I think that it could be extraordinarily difficult to implement some kind of disciplinary matrix for we have thousands of state classifications, and there are also in each of these cases, you look at each of these cases individually when we're reviewing them or hearing them, and every single case is different. Every single case has some variation of the facts. So I think that looking at creating some kind of disciplinary matrix is an extraordinary undertaking, and I see as potentially very problematic, especially if we're looking at that matrix and trying to apply it to our decisions. So I think that's something that you need to take into consideration. The other issue, I think, sort of has been answered, but I do need to ask it, and that is about the burden of proof. If you implement this disciplinary criteria, is the employee then going to be saddled with the burden to show that the penalty is outside of the disciplinary criteria, and therefore shifting the burden of proof initially to the appellant versus the respondent to prove the adverse action? Those are my questions.
Yeah, maybe if I can start,
Please.
and then I'll hand it over to you guys. First of all, the concept of having a matrix for which describes levels of penalty for misconduct is not by any means revolutionary. We see that, and we've seen that for years in criminal justice systems all over the country, including here in California, where guidelines have been developed by legislatures and other bodies in order to help make more uniform and equitable the charging of, in criminal contexts, people that break the law, and in administrative contexts, people who engage in misconduct. So it's not necessarily a revolutionary concept that we have come up with here. We have heard from employers, as the employer representative, time and again, that on a case-by-case basis, it's a very, very difficult process to determine what the appropriate penalty is for any given type of misconduct. And there are examples, Debbie gave one earlier, but multiple examples where a department in isolation is trying to figure out what the appropriate penalty is for incompetence, or what the appropriate penalty is for excessive absenteeism, or what the appropriate penalty is for any other conduct which you might see regularly, or misconduct you might see regularly. And they can look at, I think the State Personnel Board did a good job many years ago by establishing a presidential decision process, but that's not the entire answer. And what we are trying to do with the matrix concept is give guidelines to state employers, state departments, in which they can generally assess what the appropriate conduct is, what the appropriate penalty is with the conduct that's being charged. Are they going to be handcuffed by that? Probably not. That's really not what our vision is. It's certainly not our vision, I think, to handcuff the State Personnel Board when ultimately adjudicating the action and determining what the appropriate penalty is. But at the start, there has to be, I think, some assistance given to departments so that we can do what I think is part of the merit principle, and that is establish an equitable system, one that is one that's uniform and not wildly disparate in the disciplinary process, one where one can generally find from department to department the same types of penalties being assessed for the same types of conduct.
Well, just to follow up, I think the difficulty with that, just in my experience, is that, as I said, every case is different. Even though you may have two cases of excessive absenteeism, but one employee may be a 30-year employee with no prior adverse actions. The other may be a 2-year employee with no prior, with maybe one prior adverse action.
Yeah.
And in addition to the absences, typically what we'll see is some other charge. So it's, my point is that, like I said before, everything is different. There are no two cases alike. And I just would ask that you keep that strongly in the back of your mind as you're looking at these disciplinary criteria, because I think it's a much greater undertaking than I can imagine.
You know, and I just wanted to add, because the CDCR, if you will, if you look at that type of matrix, for exactly the reason that you're pointing out, that everything is different, it's a scale. I mean, it's not, you know, if you do this, you get this. It's, well, here's the scale at which this type of you know, activity would be set in this type of range as far as a penalty. So it isn't, you know, succinct in one area. It is definitely broad, and obviously that way the department has to use judgment. But again, just like Howard was saying, we're trying to at least put something out there where there is more fairness in the system. And so that departments at least know, where is the gauge? Where do I